So, good morning, everyone. My name is Mariana Pargendler. I'm a professor at FGV Law School and a co-director of our Center for Law, Economics, and Governance. In this last year, I've also had the privilege of being a visiting professor at Stanford Law School, which is when the idea for this conference came about. It's my great pleasure, really, to welcome everyone to this conference today, which is co-organized by Professor George Triantis of Stanford Law School and Bruno Salama of FGV and the Center. So first of all, I'd like to thank everyone who made this event possible. I'd like to thank Stanford for joining forces with us in this project, the FGV Business School for hosting us here today, Copies for Financial Assistance. And really our extremely distinguished panelists and panel chairs for agreeing to join in this debate. We are really deeply honored, and also the public for coming here today, and especially our dear students from Stanford and FGV. Here at FGV, we devote our lives to study the law, not only because of the inherent beauty of legal rules, but also out of a conviction that, about the role of legal institutions in social and economic development. But in thinking about the role of the law in the economy and society, it's also useful to think about the role the law does not need to play, because there are other available private alternatives to achieve the very same goals. This is, of course, especially important in developing countries, because investments to develop an effective legal system require significant amounts of money in an environment of very scarce resources. In addition to this method of thinking about the law, FGV and Stanford also share a particular concern about the role of contract law and enforcement, in particular, in structuring economic activity. This is a very important theme internationally. In fact, many economists believe that a formal system of judicial enforcement of contracts is an essential precondition to economic development. And in fact, many dollars have been spent around the world based, at least in part, on this assumption. And this is a very central theme in the Brazilian context as well, where perceived deficiencies of the judiciary, be it because it might be slow or be biased against creditors, have been blamed for a variety of evils, such as high interest rates and the very absence of a long-term market, long-term domestic credit market. And I'm here alluding to work by Pérsio Arida. This is seminal work, and we're very happy to have him as one of our panelists today. But to know what type of contract enforcement we need, or how much formal contract enforcement we need, it's really important to look at the available alternatives. So there are basically two questions that we would like to address in the conference today. The first one being, what are the real challenges, if any, in terms of formal judicial enforcement of contracts in Brazil today? And second, how do parties structure their business transactions in Brazil, but also in the US and in other developing countries, in view of the existing systems of contract enforcement? It is only by looking at these facts on the ground, by bringing the best and brightest from academia, the judiciary, law firms, and companies, that we can really begin to think about the role of law and of private alternatives in terms of having an environment that respects private contracts at the lowest possible costs. This conference also marks the launch of our Center for Law, Economics, and Governance at FGV Law School. The purpose of the center is to better understand the relationship between law and economics, not only in abstract terms, but in view of addressing the peculiar challenges of facing Brazil and the global economy more generally. We could not really think of a better start for the center than this conference, and we very much hope that this is only the beginning of a series of events aimed at understanding the relationship between law and development in Brazil. I'm not going to take any more of your time, and just want to thank you once again and transfer the microphone to my colleague, Professor André Corrêa of FGV. Thank you.
I will just explain how it would gonna work. We have Rafael, Camila, and Ana Carolina taking the question during the presentations, and they're gonna be answered at the end of the fourth presentation. Each presentation we're gonna take around 15 minutes, and they're gonna present the case, the problem, the hypotheses, and then we're gonna discuss. First presenter, Professor Jorge Triantis, is the James and Patricia Cowell Professor at Stanford Law School. He teaches and writes in the fields of contracts, commercial law, business law, and bankruptcy. Among his contributions to legal scholarship, Professor Triantis pioneered the application of options theory in the study of contracts and commercial law, and authored a series of articles that develop principles of contract design. His recent publications concern the link between contract design and dispute resolution, the design of legal remedies in commercial contracts, and the impact of bargain power on contract design, and forces of disruption and innovation in transactional legal practice. He was previously a member of the law faculties at Toronto, Virginia, Chicago, and Harvard. So, Professor Triantis, the word is yours.
Well, thank you. I'm delighted to be here, and I wanted to thank Mariana and the faculty at FGV for welcoming us from Stanford to the law school and now to the business school. And I'm speaking on behalf of my colleagues, Professor Klausner, who you will hear from, as well as Professor Daines, and 12 of our best students who have come to FGV to study the Brazilian legal and economic context. I teach contract law, and I should say that the teaching of contract law in the U.S. is in the midst of a transformation, I think. It's a transformation from thinking about the law of contracts to thinking about the design of contracts, which I will speak about in a moment. In thinking about the design of contracts, the importance of comparative study has become very, very clear. And by that I mean, how do economies and economic actors adjust to legal systems, which is just as important as how do the evolution of the economies change the evolution of the legal system. And we are all delighted to be in Brazil because it is a major economic player in the world economy with different characteristics in the legal system from the U.S. and the common law system, as well as different arrangements, therefore in different design in contracts and in other aspects. I'm new to Brazil, and I'm really looking forward to this experience, to learning about contracting patterns and contract enforcement in Brazil. And so my contribution here has to necessarily be limited to the U.S. context, or at least the U.S., Canadian, and U.K. context. So I said a moment ago that the focus in the academy in the U.S. relating to contracts has really shifted to design. And the notion of design really has come from technology and the design of new technologies. And so what I'd like you to think about as a context is think about innovating a new type of technology, whether it's a new type of phone and watch or whatever it is. And I want you to translate that process of design into the design of a contract, because contract is really a type of technology. And so when we think about the design process, we think about starting with the needs of the customer, the needs of the parties, the economic or other needs of the customer, trying to figure out how do we meet those needs, making a prototype, testing it, figuring out whether it works or not, going back and improving on the product. And this process of iterative design is key in technology, and it's also key in contracts and designing the optimal contract and being innovative in the way that you think about contract design. Now, Another principle of design is that you have to understand the environment that you're operating in. And whether it's a technology or whether it's contract, it is the legal environment, the economic environment, the social environment. Those all come to play in deciding whether people would like to access the web through their watch or through their phone. You know, you have to understand people, you have to understand the economy, you have to understand the social context. And that's equally true when it comes to designing a contract. So in designing a contract, it's important that one understands judicial enforcement, the legal environment, but also important that you understand all the extra-legal, the non-legal environment that regulates the relationship between parties that are conducting a joint venture, a joint project of one form or another. Things like what motivates people to keep their promises, even outside the legal system. What are the reputational consequences of not keeping your promise? What's the context of a relationship that arises between two parties that deal with each other over a period of time? All right. Now let me take that lesson from design and apply it more specifically to contracts. There is no doubt that a written contract serves an important purpose between the parties. It memorializes, it gets a record of what did they really agree to, so that later on in the course of performance, it's something that the parties themselves can refer to remember what is it that they agreed to. Especially when the two parties to the contract are organizations where the parties that are performing the promise, performing the contract, are different than the ones that negotiated it. It's important as a mode of communication within the two parties and also across the two parties. That's not what I'm concerned so much about. That's really a memorialization of an agreement. What really makes something a contract in the legal sense is that it invites enforcement by a third party. It invites coercive enforcement, usually by a court, but maybe through an arbitration process, through some sort of dispute resolution process, and ultimately coercive enforcement by the state, by forcing one party to pay damages to another, by forcing one party to perform through specific performance or through some sort of injunction. That's what really makes a contract a legal document, and what makes a contract as opposed to a simple memorialization of the parties' agreement. It's that third party, and let's first of all focus on judicial enforcement. In that sense, again, if you excuse me from taking a Silicon Valley or a tech-oriented approach to a contract, think of a contract as being like software, like computer software. Software is a set of instructions to a computer that will run the software through the computer. What a contract is a set of instructions to the body that will resolve the dispute and enforce the contract. And therefore, just as with respect to computer software, you have to know how a computer works, the hardware, the platform on which the software is being run, you have to understand that before you can write the software code. Similarly, in contracts, you have to understand the dispute resolution process, all the strengths, the weaknesses, and challenges of the dispute resolution process if you're going to write a contract. You have to understand who's going to process those instructions later on. So that's why there is this important connection between understanding the dispute resolution process, the way courts work, the way arbitrators work, and your contract. So you would write a different contract if it was going to be enforced through arbitration than you would if it was going to be enforced through the judicial process. Okay? All right. So roughly speaking, again, thinking in terms of software a little bit, think of a contract as a list or a set of combinations of states of the world, of contingencies, and outcomes, judicial actions. So for instance, if I promise to provide you an umbrella if it rains tomorrow, or to face liability of $25 if I don't provide you with that umbrella if it rains, then what this contract is an instruction to a court that says that if it observes that it's a rainy day tomorrow and that I have failed to provide you with an umbrella, it has to force me to pay you $25. Simple as that. It's simply an instruction to the court. So it doesn't take very long, by the way, to realize that it won't be long before a computer does exactly that. Where before there's a computer that will observe and detect whether it was raining tomorrow and whether I provided you with an umbrella, and it would automatically debit my account by $25 if in fact I don't perform when it's raining. That you won't need a court, but I'm not projecting that much in the future as to whether dispute resolution and how sophisticated dispute resolution can be by computer as opposed to by courts or an arbitrator. All I'm saying is that there's this close connection in thinking about the design of software and thinking about the design of contracts. So what the conference focuses on is the challenges to contract enforcement, particularly judicial enforcement. And there are three ways that I want to address in which judicial enforcement can be imperfect. When I say imperfect, there is no perfect judicial system in the entire world. That's not a surprise to you. Each country, each legal system has a mechanism for judicial enforcement that is imperfect and necessarily imperfect. But what makes comparative law so interesting and the comparative study of contract design so interesting is that the types of imperfection differ from country to country. And therefore, you would expect that if contracts are designed in order to address those imperfections, that contracts will vary from country to country. So I will talk about an example of how franchise contracts differ from country to country depending on judicial resolution, but I will focus on the U.S. concerns, and Paolo, and I presume others, will talk not just about franchising, but about other type of contracts and how do they address the imperfections in Brazil. So the three types of imperfections that I wanted to focus on is, number one, the limits in the enforcement capacity. Most clearly, that defendants can be judgment-proof. They may be insolvent, they may be able to hide or divert assets away from the enforcement process, and the degree to which defendants are able to shield or hide their assets differs from country to country in important ways. Second of all, and this is particularly true, by the way, in the common law system where contract damages are the predominant way of enforcing contracts. So that's first. Judgment-proofness or limitations in the enforcement capacity. Number two is judicial error. Economists like to talk about it in terms of verification costs. The costs and the verifiability of factors that are included in contracts. So you remember my simple example. I said that I promise to provide you with an umbrella if it's raining, and if I don't, the court will force me to pay you $25. Well, the court has to verify that it rains tomorrow and that I failed to provide you with an umbrella. So I could provide you with something, and the court has to figure out, is it an umbrella as promised, or is it not an umbrella? It's a binary choice. Did I breach, or did I not breach? Was it raining enough to warrant an umbrella, or raining too little? These are verification problems that a court has to encounter. They're costly. It takes time for the court to do that. And also, the court could make a mistake. What do I mean by mistake? I mean the court could come out with an outcome that is inconsistent with the intent of the parties when they entered into the contract. Just the same way as a computer could process the software in a way that's inconsistent with the intent of the coder, of the drafter of the software. So that's the second problem, a judicial error, particularly in this sort of information way, in the verifiability of factors that are in the contract. The third type of error is the cost of the process, the litigation cost, including the delay that is taken up in running this program through the judicial system. I believe, for reasons I'll touch on, but I can elaborate later, that this is the least significant of the problems. The least significant of the problems. The most significant being the judgment-proofness, and number two, the information or verification problem. So as I said, the example I wish to discuss, more by way of an example because it's not Brazil-specific, is the franchise or perhaps a distribution contract. So consider a fast food franchise such as the American and Canadian favorite of a chain of donut shops. Okay? A franchise is an excellent example of what economists call an agency contract, and it has classic information problems and hold-up threats that lawyer and economists are most concerned with in business relationships. In particular, each side in a franchise contract is making significant investments of financial capital, of expertise, and of effort that are particular or specific to their relationship. The second characteristic is that there are investments that are needed on both sides in order to maximize the joint value of their relationship. And those investments are difficult to observe, and they're even more difficult for a court to verify. Consider, for instance, that a franchisee needs to keep the store clean, needs to provide a good product, a tasty donut, needs to be respectful of the customers. Those are things that you could write down on a piece of paper that I promise to be respectful of my customers. I promise to keep the premises clean. I promise to produce a good product. But it's very hard for a court to verify without actually going into the store and tasting the donut and interacting with the employees, all of which would take a lot of time. Obviously, I'm using a very simple example here, but I think you get the basic problem. The third is that franchisees are capital constrained, they don't have unlimited funds, and therefore, in a litigation later on, they will often be judgment proof. So in conventional economic analysis, these weaknesses undermine the optimal incentives, and they might lead chains to organize themselves by vertical integration rather than by contract, rather than by franchise contract. Now, whether or not this is the motivation, an example of vertical integration is the Starbucks chain in the US, where most of the Starbucks outlets are owned by the company rather than run by franchisees. But if you look around at different type of franchises, what you see is that there is a real variation. And I'm very interested to hear about the McDonald's franchise in Brazil, because what you'll see among franchises is some of them are organized by franchise contract and have to address these issues that way, and some of them are organized by vertical integration, where they are company owned. So here are some common and interesting features in franchise contracts. So one thing that's interesting is there's a lot of vague language in franchise agreements. Best efforts, commercial reasonableness. And if you think about the cost of verifying things to a court, you say, well, why do they put in these terms that are vague when, you know, an average judge, what do they know about best efforts and commercial reasonableness in the donut franchising industry? The reason that they're there is we're dealing with an imperfect world where any precise term that is easy for a court to verify won't fit very well the needs of the parties. You could say that the franchisee has to spend 10 hours in the franchise store, but that doesn't really get to effort. You know, how do you measure effort using specific proxies? You really can't. And so they use vague terms as a way to saying, look, the court will roughly get it right, and for reasons that I can go into at another time, roughly getting it right may be good enough. Maybe good enough. Here's a second problem. The second problem is supposing that the franchisee doesn't take good enough care of the store and threatens the trademark. If you're relying on damages, then you encounter the problem of judgment proofness. You have to sue, you have to collect damages. How do you know that the franchisee really has not met its obligations? How do you measure the damages to the mark? That's a verification problem. And then once you have the damages, how do you collect from the franchisee when the franchisee is insolvent? So these contracts use termination rights. In other words, when the franchisor sees a problem, the franchisor can simply terminate and stop the contract. Now then you say, well, doesn't that make the franchise really vulnerable to the franchisor? And franchisees complain about this. Again, you're living in an imperfect world, and you can't really completely rely on the courts to determine whether the franchisor was being opportunistic and strategic in terminating the franchise, as opposed to taking care of a problem of lack of cleanliness or lack of quality product. You've got this other thing going on, and that is the reputation. So this is the broader context, and that is that franchisors who are known to be terminating franchises capriciously are going to find it hard to sell franchises, are not going to be able to sell their franchises at as high of a price later on. And this is the final point that I'll leave you with, that you've got an asymmetry here in the way that the two parties are being disciplined. The two parties are being induced to cooperate in their joint venture. On the one hand, if you look at a franchise contract, there are a lot of obligations on the franchisee, and there is a very strict termination threat that the franchisee faces. Franchisee is not subject to a lot of reputational constraint. You know, franchisee hasn't got as much invested in its trademark or anything like the franchisor. So the legal system or the termination right is what disciplines the franchisee. On the other hand, if you look at the franchisor has a lot more of a reputation invested. And therefore, when you look at the franchise contract, there's not a lot of, there's less obligations put on the franchisor, less of a termination right, that threat on the franchisor, because it is more likely to be disciplined by reputation. So when my students look at a franchise contract, they say, this is a really one-sided contract. It's really very oppressive on franchisees and very lenient on the franchisors, but this is the problem with looking at only one aspect of enforcement, only looking at the legal system. When you look at the broader context, it looks a little bit more even. It's just that there are different forces that are being applied to the franchisor than to the franchisee. And that's why I entitled this talk sort of multimodal enforcement. That when you look at the entire picture, you've got to look at the reputational constraints that operate, and they may operate asymmetrically as between the two parties. I apologize for going over, but thank you very much for your attention.
Thank you, Professor Triantis. And now we're going to hear from Professor Paulo, but before Professor Paulo going to talk about contract enforcement to the panelists, I will present you with 5 to finish and 0, and I will treat the same, so I will give you 5 minutes for all to be equally treated.
Okay.
Professor Paulo Furquim is Senior Fellow Professor at the Insper Institute. He holds a bachelor's degree in Public Administration from Getúlio Vargas and master's and doctorate in Economics at the University of São Paulo. He was a visiting professor at MIT in 2012 and visiting scholar at the University of California at Berkeley in 1994. Before joining Insper, he was a professor at the São Paulo School of Economics at FGV, at the University of São Paulo and at the Federal University of São Carlos. He is the author of a number of papers and book chapters on the following topics: antitrust, regulation, market and firm organization, and law and economics. He also was a commissioner at CADE, the Brazilian Competition Authority, between 2006 and 2009. Professor Paulo.
Good morning. Well, it's a pleasure to share this session with you, George, Michael, Carlos, and André, and with you, the audience. And I thank Mariana and Bruno and George for having me here. My topic is quite related to what George just presented. I'm going to talk about franchise and judiciary, and also McDonald's. And I start with franchising. In 4 minutes, 5 minutes, I get into the judiciary. Well, there is a key decision in franchise chains. It's an organizational decision. First, it's related to how many outlets a franchise chain has, but more important is how many of those outlets are franchised and how many are company-owned outlets. So this is a key decision in a franchise chain. And also, it's perhaps the topic in the literature that is mostly written about. So we have a lot of papers on this. But let's treat these questions in a way that probably Ronald Coase would do. What are company-owned outlets and franchised outlets? They are alternatives There are alternatives to play the same role, which is in this case to distribute a product or a service. Actually, the outlet is exactly the same, the products are the same. If they differ, it's unintentional. So the idea of having the two of this organization formed together is a choice that a franchise chain has, and we have to question ourselves, what are the reasons to choose a particular proportion of company-owned and outlets, or to choose 100% of franchise outlets? And the basic idea in a very higher general level is that this choice is driven by transaction costs. We have different transaction costs to perform a franchise contract, and we have transaction costs to perform a internal organization, which is the company-owned outlet, and that George referred as vertical integration. This is related to incentives, and we have in this literature several results. I will summarize for you. We have a huge variation across franchise chains in terms of the proportion of company-owned outlets. This is not exactly our top, but I will just summarize some results. For example, brand name value, if there's a higher brand name value, franchise chains tend to rely more on in internal organization, in company-owned outlets. Distance from headquarters, then monitoring is more costly, then they use more franchise contracts instead of company-owned outlets. Size and age also are associated with relying more in franchise contracts, and also how important is franchise actions in products quality. And just to illustrate those results, this is a picture from perhaps the most important paper in this area, LaFontaine and Shaw. And what we have here is the proportion of company-owned outlets, and in the x-axis we have years of experience of a franchise chain. And we have this regularity that I will explore in 10 minutes in the McDonald's case. Normally, franchise chains started with a very high proportion of company-owned and outlets, and then they start franchise, and they reach a stable amount, stable proportion of company-owned outlets. But we also have a huge variability across sector. For example, here we have restaurants with a higher proportion of company-owned outlets. And this is related to some of the variables that I just mentioned, brand name value and the effect of the franchisee's action on the quality of the product. So we have this effect in these several variables to explain the variation across franchise chains. But there is also a very huge variation, perhaps even higher, across countries in the same franchise chain, exactly the same product, the same brand name, and we have a huge variation across countries. And what would explain that? The key question here is, what's the difference between franchise chains and the vertical integration? One important difference is that franchise chains has to rely in a third-party enforcement or on the judiciary. So the cost, the differences in cost of conflict resolution or the use of the judiciary may explain this variability. Let's take some evidence here. So this is one of the few papers, actually 95% of the literature is about variation across franchise chains within the same country. But we have some papers investigating the difference across countries. And this is one of them. So the US, we have in average 10% of the outlets are company-owned. In France, it's 30%. France is a smaller country, and we know that size is correlated to the more intense use of franchising. So maybe this is one reason. But Brazil is a very large country as well. And in Brazil, we have, in average, 37%. And we don't have any explanation here for that, but there is a hint that maybe the use of this third-party enforcement or the judiciary in Brazil is too costly. So companies try to avoid the use of the judiciary, opting for internal organization of those transactions. Let's have a closer look at the McDonald's case. It's very interesting, I think, this case as an example, because we are talking about a product that is exactly the same everywhere. A Big Mac is exactly the same in every country. And the brand name is also the same. But we have a huge variability across countries. So what's the reason? Let's first give some basic data about McDonald's Brazil. The entry here was in 1979, first as a joint venture, not as a franchise chain. And they started franchising in 87. And it is the largest fast food chain in Brazil. And as McDonald's has grown in size and is more experienced, and we know those variables explain the use of franchise contracts, we would expect a decrease in the proportion of company-owned outlets in this case. Yeah, exactly what we see. Here we have the blue line is the number of company-owned outlets. The red line is the number of franchised outlets. And we can see that franchise outlets are increasing faster than the company-owned outlets. If we take the proportion of company-owned outlets, we see a decrease as we would expect in this period until 2000. But something happened in 2000. And this is interesting for our topic today. What happened in 2000? Oh, sorry, let's first compare Brazil with the other countries. So this is a data from McDonald's, the average of company-owned outlets all over the world in McDonald's is about 20%. So much lower than Brazil. So we have a proportion in Brazil that is decreasing, but it's still very, very high. In the US is 14%. So it's a huge difference between Brazil and the rest of the world. But it is decreasing. And I was telling you that something happened in 2000, and it's interesting to see the results of this happening. And it was a battle in the judiciary. What happened exactly as in 2000, several franchisees sued McDonald's. They basically claimed that the McDonald's was overcharging for inputs. Also, they claimed about cannibalization, which is opening new outlets close to existing ones. So the competition between outlets, of course, had a negative effect on the profit of each outlet. Also, McDonald's, and this is important in this case, is the owner of the area where the outlets were located and charged a rent that was variable according with the turnover of the outlet. So the rent was variable, and this was not common in Brazil. And also, and I submit, this is actually the most important reason, several franchisees, they had a debt in dollar, and we experienced a huge devaluation of the Brazilian currency in 1999, exactly the year before 2000. And in about 4 months, the debt almost doubled. And so you have a problem of solvency here. In 2003, the judiciary ruled against McDonald's, only in the topic of the rental practice. All other charges were dropped, but we have this decision. McDonald's could not use this rental practice that is common for McDonald's all over the world. And this was what happened with McDonald's strategy. So we see that the blue line, again, is company-owned outlets. The red line is franchised outlets. So we can see in this picture that McDonald's is substituting, after the decision of the judiciary, is substituting franchised outlets for company-owned outlets. So the consequence of this, the proportion of company-owned outlets that was decreasing in the first moment started to increase a lot until it reached 75% in 2006. But maybe this was a problem of Brazil, and maybe this happened with other franchise chains. So it's interesting to see what happened with the McDonald's competitors. So let's see what happens with McDonald's competitors. So McDonald's is still the blue line. The red line is Habib's. Brazilians know. It's a food chain also. And Habib's experienced a decrease in the proportion of company-owned outlets, but more strikingly is the case of Bob's, which is the closest competitor to McDonald's. They sell exactly the same type of product. And Bob's decreased from 70% of company-owned outlets to about 14%. And so I use those examples as counterfactuals. And we can see that the decision of the judiciary affected McDonald's only and not the other franchise chains. And this is related to the type, to the design of contracts that McDonald's was using in Brazil that was different from what the contract those companies were using. Some years later, actually McDonald's is doing pretty well. McDonald's has now, this is 2015, almost 900 outlets. It's a 60% increase over 2006, the last data that I just showed you. So it's doing pretty well. And the proportion of company-owned outlets and franchised outlets is exactly the same, which is a signal that is a regularity across franchise chains. They have this as a target. And what happened with this intervention was that McDonald's shift its target from 40-something to 75% of company-owned outlets. So McDonald's is trying to avoid third-party enforcement in Brazil. And I think there are other evidence that is, I think, quite interesting. Since 2004, so McDonald's still uses 25% of franchised outlets. But since 2004, no new franchisee was incorporated in the chain. Since the judicial decision in 2003, we can say 2004, no new franchisee was incorporated. So how McDonald's increased franchised outlets without new franchisees, with the old franchisees. So the very same 62 franchisees that McDonald's had at the time, and that were not litigating against McDonald's, those are the ones that are managing those new franchised outlets. So this is a different type, I would say, of franchise contract. The contract may be designed exactly the same, but the selection of the person in the other side is completely different. It's a person that McDonald's trusts. McDonald's has a very good information about the behavior of that person. And this is the 25% of franchised outlets in McDonald's in Brazil. So just to finish, so is McDonald's really avoiding the judiciary? Well, we have an evidence in this direction. I'm sure about that. We can document that it was very costly for McDonald's to run franchising contracts in Brazil. And the strategic response was consistent with this because it's a clear trend of substitution between franchised contracts and company-owned outlets. And also this reliance on this particular type of franchisees in which we can claim that McDonald's trust more because they have an experience with these guys. But was McDonald's successful in avoiding the judiciary? I would say that partially yes. We don't have cases of litigation between franchised outlets or franchisees and McDonald's, but not exactly. This, I collected this news 2 weeks ago. And for our friends that are not Portuguese-speaking persons, this is the labor union just sued McDonald's in a very huge scale in Brazil. What I think is interesting is that, first, McDonald's is substituting a contract, a private contract, a franchise contract for internal organization. This is not having contract. This is the labor contract. So the McDonald's is liable to respond for the labor contract. But I would say, not having studied this in depth, that McDonald's probably would be sued because of this issue anyway, because they actually they are not only suing McDonald's company-owned outlets. They are, the lawsuit is against the whole franchise chain. So probably is something that would happen anyway. Well, thanks for your attention.
Okay. I receive a note here. Just to reinforce, the questions should be made by reading and direct to Rafael, Camila, and Ana Carolina during the presentation. And just raise your hand, and paper and pen will be right beside you. Okay, thank you, Paulo. Now for the third panel. Professor Michael Klausner is the Nancy and Charles Munger Professor of Business and Professor of Law at Stanford Law School and visiting Professor of Law at NYU. He teaches courses on corporate law, corporate governance, business transactions, and regulation of financial institutions. In recent years, most of his reading has been on corporate governance. He maintains a database on securities class actions and SEC enforcement actions and has written papers and blog posts based on that database. In addition, Professor Klausner is currently reading a book and producing an online course called Deals, the Economics Foundations of Business Transactions. And before beginning his academic career, Professor Klausner practiced law in Washington, D.C. and Hong Kong. He was a White House Fellow from 1989 to 1990, a law clerk for Judge David Bacelon on the United States Court of Appeals for the District of Columbia Circuit in 1981 and 1982, and a law clerk for Justice William Brennan on the United States Supreme Court. He's a graduate of the University of Pennsylvania and Yale University, JD and MA in economics. Professor Michael.
Well, thank you. I'll appreciate, the same appreciation has been expressed by my co-panelists. I express as well. Thanks very much. So I'm going to do something very simple. My assignment was to have a case study that will illustrate a thesis. And the thesis is that legal enforcement has limits and that therefore parties may want to reduce their reliance on legal enforcement and increase their reliance on non-legal enforcement. So I'm going to just give you a single contract. It's a real contract. The names are changed because there is some confidentiality involved, but the facts are accurate. It's a contract between a semiconductor manufacturer and the manufacturer of a tester of semiconductors. These are two high-tech businesses. Semiconductors, as you probably know, are some sort of thing inside a computer or a telephone or a camera. That's as much as I know about them. They seem to make them work fairly well. But they only work because they are tested. This testing device is a very important input into the semiconductor manufacturing process. Every semiconductor, meaning every single one, is tested. And therefore, the number of testers needed by a semiconductor manufacturer is the same number as the number of semiconductors that it sells to camera manufacturers or computer manufacturers or whatever else. Testers are also custom made at the high end. At the high end, they're custom made for semiconductors. In addition, the manufacturing of testers entails high fixed costs. Plant and equipment are specialized, expensive, and take time to build. So that's the setting. Now we have two companies. I call them TestCo, the producer of the tester, and Semico, the producer of the semiconductor. Semico is a company like Intel or something like that. Tesco, in this case, in real life, is a small startup that has an innovative technology. It's a technology that allows it to produce testers that are more accurate and that operate more quickly and can be used for any number of high-end semiconductors, but to use this technology, it has to be customized for a particular semiconductor. So here we have Semico on the other side. Semico is a very large public company. You can think of it as Intel. Frankly, I don't remember whether it's Intel or not, but think of it as Intel. It's a big company. And it wants to buy testers from this small company because of the intellectual property and patents that it's developed. So that's our setting. Tesco, Semico want to enter into a contract where Tesco produces testers for Semico. Sounds simple enough, but there are some concerns. So whenever you enter into a contract, you think of the concerns of each party. What are Tesco's concerns? Well, Tesco has to invest in plant or equipment, or someone has to produce a new plant, an entirely new fabrication operation with specialized equipment that will be customized to a degree for Semico. Now I say to a degree because with enough advance time, the customization can be changed for another company, but that takes some time. Some of the customization is in the software. That's quicker to do. Some of it would be in the hardware of the equipment in the factory. So that has to be built up front before anything can be produced. Tesco is worried about whether Semico is going to make enough orders. Now, Semico has not started producing the semiconductor that it wants to have tested. So it doesn't know what its demand will be. It has some projections, but it doesn't know what it'll be. It depends how well this semiconductor works. So Tesco is worried not only will Semico somehow cheat it in some way, but simply whether Semico is going to have enough orders. Now, it is also concerned about the possibility of cheating. Now, what would cheating involve? Semico needs these testers. There's no question about that. It needs testers that work. So it's got to buy them from somewhere. The concern is that Semico will buy them from somewhere else, and therefore not order enough from Tesco. So those are the concerns. Will Semico buy enough from Tesco? What are Semico's concerns? Tesco is a young company. It has some experience in actually producing testers and using them and selling them, but not on this scale. So Semico is concerned that Tesco won't be able to supply enough quantity. Semico is not really related that Tesco will cheat it in any way. This is an enormous benefit for Tesco. Being able to sell to Semico is huge for Tesco's business. So it's not worried about being cheated, but it's worried about Tesco's abilities. It's got to produce quantity at the time needed. Because as I said, every time a semiconductor, a little one, just one of them, is sold, it has to be tested first. It can't go out the door. And if Semico is behind in supplying its computer manufacturers or telephone manufacturers, it's going to have a big problem. So, let's imagine a contract, a simple contract. It'll say, Tesco will build the plant and equipment and it will supply testers. Semico will buy a fixed quantity of testers for X number of years. And you can imagine that that could be a contract that satisfies Tesco, that it'll sell enough to make enough of a return on its manufacturing facility. But how effective is legal enforcement going to be for Semico? The answer is not very effective. First, what if Tesco fails to build the plant? Not on purpose. Things go wrong. It runs out of funds. It has some other problem. If it fails to build the plant, Semico is not going to have time to find another source. Similarly, if it fails to produce the adequate supply, Tesco is not going to be able to just buy it at the corner store. Semico is going to have a big problem. So there won't be time to sue, get compensation, and find another supplier. In addition, even if it could get compensation, what will that compensation be? It's very hard to estimate lost sales when, especially if the plant isn't built, nobody knows what the sales will be, and even once the plant is built and supply starts, it's hard to project sales. So that's going to be an uncertain element of the legal enforcement mechanism. Finally, maybe most importantly, Tesco is a small company. It doesn't have the money to compensate Semico anyway. So legal enforcement is not going to be very effective in this setting for Semico. What about for Tesco? It isn't bad. In our simple contract, Semico is going to buy a fixed number of testers. That's easily measured. It's easily, in George's terms, easily observable, easily verifiable. It's pretty simple. But is that an ideal contract? A fixed quantity could result in either too many or too few testers being produced. Too many means that Semico's got to throw away a lot of the supply that it has bought. That's a deadweight loss on society. Tesco will get paid for them, but there's no good that comes of it, and the possibility that that Semico will have to throw those away will enter into the price that Semico pays for Tesco. If it produces too little, of course, if Tesco produces too little, then we have a real problem, because Semico is selling to big, computer, telephone manufacturers, and if it can't supply, it's got a horrible business problem. So while legal enforcement could work, the contract, the simple contract that I put there, is not the ideal contract for either side. So now let's look at what they did instead. This is, as I said, I've been told to give a case study. I'm going to give you a case study of what they did to try to solve these problems, to try to come up with a mix, as you'll see, of non-legal enforcement, ultimately, however, with a background of some legal enforcement. So if you had zero legal regime, this still wouldn't work. But this is a contract that minimizes the reliance on legal enforcement. So how did it work? First, let's see what contractual assurance there is for Tesco. First, Semico is paying for the plant and equipment. So Semico is buying a plant for Tesco. That makes sense, because Semico has the best information about what it's going to buy. It doesn't have perfect information or anything close to perfect information, but it has the best information. And the payments will be made at identifiable milestones in the production. Semico also commits to a minimum monthly purchase of testers. That's under the capacity of the plant that it's going to build. As the slide says, it's going to build excess capacity into the plant to add flexibility. So flexibility will be built, but the minimum orders will be under capacity. Tesco, however, can use that capacity for third-party sales, as long as it has time to retool to do that. Semico also commits to quasi-exclusivity. I'll get to the quasi part in a moment. Think of it as exclusivity. So what do we have here? We have Semico. If I am exchanging the word Tesco for Semico here and there, I know I do that. I've done this many times with this case, and it's just impossible for me to avoid. Semico commits to something like exclusivity. It'll buy all of its stuff from Tesco, with an exception I'll talk about in a moment. It's got a minimum monthly purchase, and it is allowing Tesco to use the excess capacity for other sales. What about assurance for Semico? Semico is allowed to project orders 9 months in advance and get Tesco to commit. So in effect, you can think of it as 9-month contracts, 9-month fixed quantity contracts. Semico can order more a month in advance, and if Tesco can produce them, great, but there's no obligation. So they've in effect obtained a sequence of 9-month commitments. Here's another key thing. Tesco must license its technology to a second source, another company, a third party, that will build a plant just like Tesco's and sell to Semico. That's part of the contract. If Tesco can supply the orders that Semico makes, that second source can only be used for 15% of Semico's quantity. That's the quasi-exclusivity. So there's a second source out there producing a small amount. But if things go badly, then it can buy everything from the second source. Am I out of time? Oh, wow. I have a strong incentive here to be faster than George. So let's skip a few slides. No, I think we'll be fine. Semico. So let's recap this. There's a commitment to 9-month fixed quantity or specified quantity orders. In addition, there's a second source, which is a huge part of this deal. And it could only happen if Tesco licenses its technology to this second source. So what's gained by this? Tesco has an assurance of a return on its investment. First, its investment is much lower because Semico is buying the plant. Tesco still has expenses. It's got ongoing expenses of employment and other variable costs, but Tesco is assured of a return on its investment. Semico is not dependent on Tesco, which was its original concern, and quantity is flexible. Excess capacity is not going to be wasted, at least to the extent it might have been if Semico required a full production of the most it could need. So this is an improvement. There's still some vulnerabilities, however. Semico may inflate those 9-month projections. They're not obligations. If I didn't make that clear, I should. They're not obligations. They're projections, and Tesco has to meet them. So it's a one-way obligation, and Semico might inflate those. Second possibility, Semico may fall short in delivering on that. It just may not be able to produce as hard as it may try, and there may be some delay in getting the second source to produce more. So there's some vulnerability. So what does the contract do? Two contract provisions respond to that. First, Semico, in its projections, must be commercially reasonable. It must make commercially reasonable projections. Second, Tesco must make commercially reasonable efforts to fill orders. How effective is that? Not at all. Not at all. Nothing. It's useless. Something close to useless. Those legal protections really aren't very useful at all. They're expensive to litigate, highly uncertain who's going to win. But there's some non-legal mechanisms built in. First, Semico is going to invest in Tesco. Now, Semico is a big company. If it loses that investment, it's not going to drive it into bankruptcy, but it will have an incentive in Tesco becoming successful in the future, which requires it to be successful today under this contract. So it reduces the incentives of Semico to exaggerate the 9-month projections. Second, there's joint management processes. The two companies get together every month. Semico makes 2-year projections, 1-year projections, 6-month projections, 3-month projections. That's conveying information. And again, it's an investor. It has an incentive to convey good information. Tesco also has to report its inventory. So if things are getting low, Semico has advance notice of that, and the two companies can coordinate. Finally, there's mutually assured destruction here. If Tesco doesn't produce, it's going to fail. It's out of business. Semico is an enormous company that it has to impress, and if it doesn't, its reputation will be ruined. So that's for Tesco's incentive. I'm at 0, geez, but I'll be still faster than George's wrap-up. If Semico cheats on Tesco, Semico doesn't have much incentive to do that. It needs the supply, and it needs it quickly, and there's a delay in getting supply. It could force the second source to produce more, but that's risky because the second source has a limited license from Tesco and can't exceed it without risking its own legal vulnerability. Plus, there may be reputational concern. Being a second source is a business in the technology industry. So, there are gains to cooperation as a result of this contract. The contract promotes that cooperation, but ultimately legal enforcement still has to be there. What if Semico succeeds in getting the second source to produce more? Or what if somehow Semico steals the technology and finds another source for these testers? Ultimately, if there's no court there, that would be a danger. Those, however, are relatively easy contracts to enforce, so if you got a court that's reasonably competent, it'll work. The legal system will provide that protection. What if Tesco doesn't meet its 9-month projections? Again, that's an easy contractual provision to enforce. So what we've done is we've produced a contract that is relatively easy to enforce, if it has to be, but we've reduced the odds that it needs to be enforced. But ultimately, we can't get rid of the recourse to the legal system entirely. We've just reduced it. So, I don't know if I beat George or not here. I don't think I did. Next time.
Okay, thank you, Professor Michael. Our last panelist for the morning, Professor Portugal Gouvêa, is the founding partner of PG Law, a boutique law firm focused on corporate governance issues applied to mergers and acquisitions, capital markets, and commercial litigation. Mr. Gouvêa is Professor of Commercial Law at the University of São Paulo Law School. He earned his SJD degree for Harvard Law School in 2008, having received a grant from the Fulbright Commission for his doctorate studies. Mr. Gouvêa has a Bachelor of Law degree from Universidade de São Paulo, Brazil. From 2007 and 2009, Mr. Gouvêa practiced law at the firm De Bevoise et Plimpton LLP in New York. From 2002 to 2003, he was a founder and coordinator of social networks for Conectas Human Rights, a nonprofit organization based in São Paulo, Brazil. And Mr. Gouvêa is currently a member of the Capital Markets and Corporate Governance Commission of the São Paulo State Bar Association, of the Legal Commission of the Brazilian Institute for Corporate Governance, and president of the Fulbright Alumni Association in Brazil. Professor Gouvêa.
Thank you. Well, first I would like to congratulate Bruno and Mariana for the launching of the Center for Law and Economics and Governance. And I think it's a great opportunity to have the chance to speak with all of you and establish this kind of exchange. And I'm here to play the role of the lawyer and present an idea of how lawyers react to changes, and mainly on case law, and that's the idea here. And I would like also to thank George Triantis in the name of the whole Stanford Law School delegation for coming to visit us from afar, and that's an honor for us. So my topic today is negotiable instruments, and it's an interesting topic because recently, I think about 2 years ago, the students at USP, they had a strike to change the curriculum of the school. And funny enough, most of the students said that they wanted the negotiable instruments class to be taken out of the curriculum because they thought it was too boring and useless. And as one of the professors responsible for teaching that, I was a bit, unhappy about it. But I have to say that thinking hardly about the subject, they might be right. And that's the idea here, the depth of the law of negotiable instruments and the substitutes that are being developed in this interesting relationship between 5 parties, ideal parties that I will present to you today. The parties are basically a seller, a buyer, the judiciary or the government divided between the judiciary and the executive, and also the banks and the lawyers at the end of the row. So to present this story, I will basically divide it in 2 parties. First, I will present the theory of negotiable instruments as it developed in the last five centuries, and the new developments that changed how we interpret this kind of doctrine in Brazil. So the history of negotiable instruments is started most with more relevance with the Medici Bank first in Rome and then throughout Europe. And the Medici Bank used 2 instruments very creatively. First, they were the first institution to use widely double entry bookkeeping, the basis of modern accounting and the basis also of modern corporate existence, basically. And they also use very creatively the bills of exchange, one of the most widely used negotiable instruments. And they used it very creatively to overcome usury restrictions in Europe at the time imposed by the Catholic Church. And how they used that? Basically, those bills of exchange were exchanged between currencies. And what happened was that the Medici Bank was the largest, most important bank, so it had some control over currency exchanges. So what they would do is that they would ask someone to go to their bank and deposit some currency, and the bank cashier would make a statement of how much money was deposited, and then they would establish an exchange rate for this money to be exchanged, for example, from Rome, the currency in Rome to the currency in Brussels or London or Paris. And what they would do is that in this exchange rate, they would include some interest rates. So what happened was that the interest rates would be built into the exchange arrangement between those parties, and this would all be recorded in one single document, a letter basically, that would state how much the other branch would have to pay them in this different currency. And the great thing here is that for it to work, what you would have to do is detach the letter itself from the event in which the person went to the bank and deposited that amount of money in the bank. Because if you were to actually look through it, you would notice that they were violating the usury laws. So to detach basically that document from the usury laws, you had to create an abstraction in which you would say, with that document, you don't need to look back. The document itself, it's good enough. And then we, throughout time, developed the theory of negotiable instruments that is based on the idea that those negotiable instruments are abstract. They are abstractions. They are based on basically 3 principles well devised by an Italian commercial law author, Vivanti, probably the most famous Italian author, and he devised those 3 elements. The document is the central element, the literalness, what we call literalidade. So what is written in the document is the absolute truth about the document. And then the independence. The document is independent from the underlying relationships. And that's what made those documents negotiable. They could circulate in the economy because they were independent from the underlying relationship established between the person who deposited the money in the bank and the bank, or basically detached from the contract itself. And what that meant was that the document was the truth on and by itself, and then someone couldn't really discuss, you know, I didn't deposit that amount of money in the bank, I deposited much more, or, you know, that was not the actual exchange rate, you earned some money out of it that was usury. You couldn't do that because it was independent from the underlying relationship. So I thought that very interesting because if you look at it, in art, abstractionism only came out, you know, last century. And lawyers devised abstraction at least 400 years earlier, you know. And people say that lawyers are boring, you know, like we're artists, you know, like we create things. And as Tullio Scarelli, also another Italian law professor, Italians really love negotiable instruments, you know, because of that history of theirs. But he also said that, you know, negotiable instruments were the single most important legal invention up until our times. And we could say, yeah, that might be true. You know, negotiable instruments developed into, you know, the building of bond markets in the Netherlands that helped to fund probably the first large multinational company, the Dutch East Indian companies that served as grounds for the development of stock companies or corporations in England afterwards. So in a sense, there is a strong relationship between those events and the end of the Middle Ages, the transition to merchant period, and then the rise of industrialization. But because of that history, should we still be so attached to those theories? Should we believe that legal documents should be abstractions detached from reality? And that's something that I would like to discuss with you. And one interesting aspect of that is that even during last century, people still believe that negotiable instruments would be central for such things as building peace in the world. So the Hague conferences of 1912, they were devised under the idea that if you created a universal law of negotiable instruments, that would increase commerce, and that would eventually have prevented, you know, First World War, Second World War. Well, that was the idea behind it. It didn't work so well, but they managed quite well to basically develop a theory of negotiable instruments that was quasi-universal, because, you know, England and the United States didn't like the structure of the convention so much. And I found an interesting paper from Anders Lorentzen in which he mentioned that this kind of structure of the theory of negotiable instruments as it developed on continental Europe was not very adaptable to the common law tradition because it was too formalistic. You know, and until today, like negotiable instruments, in my perspective, in most Anglo-Saxon and common law jurisdictions, they are interpreted as contracts. And the traditional theory of negotiable instruments on civil law and countries influenced by continental civil law, as Brazil, would interpret them as obligations, as a single-party obligation, or, well, half of what we would understand as a contract. But the interesting thing about negotiable instruments in Brazil is that we devised our own negotiable instrument. You know, we have samba, caipirinha, and duplicatas, yeah, our own invention. And it's a very interesting negotiable instrument because it played different roles throughout history that explain why they became so widely used in Brazil. And I would say, when I started working as a lawyer, every single client of mine, every time they would make a sale, they would issue those duplicatas. It's like the bread and butter of any company that sells services or goods in Brazil. It's always done through the issuance of a duplicata. And it's interesting because one of the first regulations of this duplicata, which is very simple, is an invoice, and the duplicata is a duplicated invoice. So one invoice would basically tell the client, well, the purchaser of your goods, what they are purchasing, and the other would be something similar to a warrant that could circulate and would provide the time in which this buyer could pay the seller, let's say 90 days from the day in which the goods are delivered. But one interesting thing is that the first regulation of the duplicatas that made them not only a commercial practice and custom, but also a regulated instrument, was used to actually levy taxes on merchants. So it became customary in Brazil for the sellers to finance the purchases by means of the duplicatas, and the government kind of noticed that. You have to remember that we are talking about 1922. Brazil was a rural country with like a small government, and it was hard to levy taxes. So they noticed that practice, and they said, you know, why don't we ask every person that issues a duplicata to put a seal, and we will charge some taxes to put that seal, and the document will not be enforceable if it doesn't have the seal. You know, that's a pretty good way to enforce a tax collection as well. So they did that. Afterwards, in 1936, fortunately in 1934, we had a change in the constitution, not very democratic, but a change. And one of the changes was that the federal government could levy taxes on commercial activities. So the use of the duplicata was not that useful anymore, and we started having taxes on trade activities. So the duplicatas were regulated as purely a negotiable instrument at that time. But it had some very interesting features. One of the ones that I liked the most is that it was the issuance of false duplicatas was criminalized, so it was a crime to issue false duplicatas. And also, it was made mandatory on the issuance of any kind of contract that would provide a term for the buyer to purchase a good. So anytime that a seller would want to finance any kind of purchase, they would have to obligatorily use the duplicatas. That was one of the features. And every seller would have to have a book to register all the duplicatas that were issued. The current legislation is a little bit more flexible, so it's no longer mandatory to issue duplicatas on every time that you have a sales agreement with providing a term for your buyer to purchase your goods. But you still need to keep a book of duplicatas, and it's still a crime, but not because of the duplicatas law, but because of our criminal law code. So duplicatas are still very important in our economy, and it's interesting to understand why they are so important. So the first reason, and the most important one, is that the duplicatas provided financing for most of the participants in industry and commerce outside of the banking system. And as most of you know, since Brazil was a country until recently with high inflation and also high interest rates, that explains why companies did not have access to the banking system to obtain credit for, cash flow and things that traditionally in other countries companies use banks for. The other reason is that duplicatas allowed for something called protesto, something that was eliminated from the legislations regarding negotiable instruments in most countries. What is the protesto? The protesto is basically a registration of the defaulted negotiable instrument or a duplicata before before a notary public. So it would be a mechanism to make it public that someone defaulted a credit against you. And the protesto is also a requirement for you to file a lawsuit to collect. But also, duplicatas allow you to use a feature of our civil procedure structure, which is what I translated as a fast-track collection lawsuit or proceeding, execução civil, which allows you to basically require, in most cases, your counterpart, the defaulting part, to basically secure the court regarding the claim before they can respond to the claim and eventually ask some, present a defense in that particular claim. And also, and then it's a new development, most recently, with changes in the Brazilian economy, basically the reduction of hyperinflation, commercial parties started to use the banking system more to obtain loans and longer term loans and revolving loans mostly. And one of the mechanisms that the banks devised to basically provide some kind of guarantee for those loans would be to request the sellers to transfer, to basically, as I will mention wrongly, assign these credits to their, to the banks as a guarantee. But the thing is, that assignment procedure is not in accordance with traditional doctrine of negotiable instruments. They would have to be basically endorsed to another party so that you would protect the abstraction nature of this title. So the bank would not, well, basically, the purchaser would not be able to present defenses against the bank. But one funny thing is that the central bank regulated that system, regulating the form in which banks could issue what I call like a bank slip, an electronic bank slip, that is sent to the other party for the party to make the payment. And that would be electronic representation of the negotiable title, which would be an electronic negotiable title. But if we look at it, this document, which is a regulated document according to regulations by the central bank, has many provisions that are against the traditional doctrine of negotiable instruments. And also, the parties playing with the electronic system, they also make mistakes. So what are the mistakes here? It is provided that the name of the company issuing the instrument would be a cedente or a assignee. And according to the doctrine of negotiable instruments, when you assign a negotiable instrument that should have been endorsed, what you do is that you denature that and you transform that in a contract. So it's not anymore a negotiable instrument. Also, with regards to duplicatas, and here the species of the document says like duplicata mercantil, what mentions the kind of negotiable title that underlies the banking slip. It could only be issued against merchants. That's the idea. You cannot issue a duplicata against a customer, for example. And then we notice that that happens all the time. For example, in this case is an example from Banco do Brasil on how those should be issued, and it's a duplicata issued against a customer. But the interesting thing about that is that for a long time, lawyers relied on a stable case law, especially in the state of São Paulo, that said that those bank slips were not regular duplicatas. So in a sense, you knew that you could present a defense to your client saying, you know, that's just wrong, that doesn't follow the legislation regarding negotiable instruments. So you cannot use that fast-track collection system. You have to use the regular collection system that takes much longer. It provides much more protections to debtors. But that changed in 2011 by a decision by the STJ, the Superior Tribunal Court of Justice, that basically rules all federal cases regarding private law. And basically, they regarded those banking slips as electronic negotiable instruments. And the court decision is very interesting because it says, you know, customs change. We have now all these electronic mechanisms. That's the standard practice of the market, and it should be recognized by the courts. A pretty modern kind of decision that goes against the traditional abstract theory of negotiable instruments. And one interesting thing, looking at some information from Serasa, which is the main credit history company in Brazil, it shows that if we look from 99 up until now, and that's an index in which the number 100 would represent the average for those elements on 1999, and it shows basically the variations in the number of protestos, but also on credit card defaults, on check defaults, and on banking loan defaults. And what we notice is that the defaults on checks and protestos, which would make reference to negotiable instruments, they remain pretty stable up until, you know, a few months ago when the crisis started. But if you look at credit card debt and banking debt, it increased tremendously, multiple times. That also demonstrates that those kind of mechanisms have been much more widely used by legal entities than they were in the past. So the conclusion here is that what would be the advice, after that change in the case law, would be my advice for my clients? It depends. For example, if I'm representing a buyer, I would ask them to try to include in a sales contract a provision saying that the seller is forbidden from issuing duplicatas, because I know that this would undermine my position afterwards if I were to be in a default. And if I were the seller, I would do the opposite. I would use my negotiation power to try to include a provision saying that I could issue a duplicata, and more than that I could transfer that to a bank to obtain credit. So the interesting thing in that whole story is that beforehand, for the duplicatas, you basically didn't need banks and lawyers. And then afterwards, banks and lawyers came into play as third parties, doing a work that beforehand was done only by the government, regulating the duplicatas and enforcing the duplicatas. So now you have a third party, private parties, helping to solve those problems. And a lot of it is done by means of reputation. Reputation of the parties before the banks, and reputation of the banks before the courts and before society in general. So the banks should not basically litigate as they would if they were these individual sellers, because they now can think of it in a strategic way. They can basically strategize the way that they litigate. They can calculate, they can see how many times they can negotiate those debts, and they can think of that on a more systematic way. So in a sense, that change in the case law might not have had the effect that was once devised of modernizing negotiable instruments law. It might actually kill and eliminate the use of negotiable instruments. But the conclusion is it might not be a bad thing for our economy. Thank you.
Thank you, Professor Carlos. Well, we just don't have any more time left. We have just time for just brief question and a brief answer. And we have just a brief question here. Let's wait for the brief answer. And then we go to the coffee break, because we are already entering the time of the next panel. I can read, yeah. Are innovative, atypical contracts rather prone to third-party enforcement because of this lack of previous regulation by the legislative? This question is to Professor George Triantis.
Yeah. So the question also refers to the analogy on the software. There's a risk to being innovative in designing a contract, and that is, remember, a contract is a set of instructions to a court. Well, if the court is used to getting a certain pattern of instructions and you ask them something new, you put a new set of instructions, there's a great unpredictability and risk as to how it's going to be interpreted by a court. So what are some possible responses, both socially and also privately? I've got two to offer because I know we're short of time. The one is, think about how lawyers do contracts. It's typically reactive. A client comes in, says, I need a contract for a specific type of a case, and the lawyer will sit down and write it. And if the lawyer writes something innovative, an innovative design, that's a lot of risk to put on that client, to go and run the risk that it'll be interpreted in some way that's inconsistent with the intent later on. Think of lawyers instead as being more proactive, and that is, if you think of a lawyer as contemplating a certain type of transaction and then saying, well, in this type of transaction, I can think of an innovative way to design and then go out and sell this new product, a newly designed or a differently designed contract to various people who are interested and who would benefit from that innovation. Well, then that's not putting the risk on one person, that is spreading the risk and also having more of the product out there. So if you compare it to technology, it's like no one's going to say, well, what are you interested? One person, what type of technology are you interested in? Let me tailor-make it to your interest. Rather, the technology companies are saying, there's a demand out there. We will produce a product that many people are interested in, then we'll market it. So you see, it's a change in the mindset of thinking about the role of lawyer in designing contracts. The second one, very briefly, is remember that in the software example, you can also change the computer a little bit. You can change the platform on which you are, or choose the platform on which you are innovating some new software. So an important part of a contract is the terms in the back that are dispute resolution. And that relate to dispute resolution. We tend to think, oh, do you want arbitration or do you want judicial enforcement? Well, there's much, much more, at least in the United States. Not only can you pick judicial, but you can also pick which forum, which state you want it to be litigated in, as well as you can give instructions to the court as to how to litigate it. Do you want a one-day trial or do you want a 6-day trial? Do you want a jury or do you not want jury? Do you want lots of discovery or limited discovery? What kind of evidence is admissible or not admissible? So to a large extent in the United States, the laws of procedure and evidence are what we call default rules. You can opt out of them. You can choose something else. And by choosing something else, you can design the platform against which you are going to, as well as a software that's going to be applied on it, which gives you a lot more flexibility and which can avoid some of this risk as well. Thank you.
Thank you, Professor Triantis. I'm going to finish the panel, and we have the coffee break. Thank you for all the panelists. 50 minutes for the coffee break, okay? See you later.